Hello, Contrarian Dude here, and welcome to another This Week in Tyranny for December 21st, 2015, my son's first birthday, so happy birthday, son. I am super excited about this week's episode. This is going to be my favorite episode for sure so far. I get to tell you one of the most incredible courtroom drama stories ever in the history of the world. This is such a cool story. It should be a Hollywood blockbuster, but there's no way in the world you'll ever get a Hollywood blockbuster made on this topic. It should be taught in elementary school, in middle school, in high school, and in college, and there is no way in the world they will ever teach it in those environments. They do not want you to hear this story, but it's so important. So this particular court case set the precedent for two of the most fundamental freedoms that we have and protection of citizens from government. The first is religious freedoms. It was in this court case that the first precedent was set that the government, the state, the king could not force you to believe in a certain religion, and each person on their individual own could decide what religion they were going to follow. And the second was something called jury nullification. Now, that's what I'm going to tell the story about today, because most people understand the importance of religious freedoms and what later became the separation of church and state. Most people get those concepts, but this concept of jury nullification is something that few people understand. And Thomas Jefferson said that jury nullification is the most potent weapon we have as a defense of liberty. So I want to slow down and stress this point, because it's obvious, but you might not think about it. Obviously, Jefferson knew about voting and the ballot box. All right, we are led to believe in the West, if you go to government-run schools, that by voting and casting your ballot once every 4 years, that is your mechanism to defend against government tyranny. And the Founding Fathers knew this was not the case, and that's why they included in the Constitution the right to, before you were deprived of liberty or property, you were had the right to a trial by jury. Now, this is a very important point. It is a right to a trial by a free jury that is our best defense against tyranny. And if you have a cause that's near and dear to your heart where you think the government has overreached, a common one might be marijuana legalization. If you think this marijuana being illegal is just nothing short of ridiculous, and you hate paying for that, all of the money and effort that you campaign to make marijuana legal and sell its benefits, I can tell you, we might get there one day, and I certainly hope we do. We've made some grounds in some states. But the far easier path to get to is actually using these concepts of jury nullification and trial by jury. And you'll understand that more as we go through. So no matter what your cause is for trying to restrict the levels of government and restrict tyranny, understanding this is your path of least resistance, and something that's very, very cool. So, first of all, let's go and take a look at this clip. A man was just jailed for passing out a pamphlet. Obvious First Amendment problems there, but let's take a look at the clip now.
A Mecosta County man is facing a 5-year felony for obstruction of justice after he says he was arrested for passing out flyers on jury rights to anyone who wanted one.
Yeah, his attorney calls it outrageous. It was in court this morning for a pretrial conference when the defendant refused to take a plea deal. And Fox 17's Dana Chiklis joined us outside the Mecosta County Courthouse with the very latest tonight on the controversy.
This is the sidewalk where Keith Wood tells me he stood just days ago passing out this flyer. It's authored by the Fully Informed Jury Association, talking about jury rights, specifically a juror's right to vote their conscience. Keith tells me he was speechless when he was arrested for passing out this piece of paper.
There's so much good information in here.
Keith faces jury tampering and obstruction of justice charges, a felony that could land him 5 years in prison. His attorney Dave Coleman says it's an attack on free speech.
It's just a blatant, illegal, improper use of government power to squelch a person's constitutional rights to free speech. That's what this is.
Keith's motivation here is informing people that they have the right as a juror to vote their conscience, something also known as jury nullification of law. Essentially, it's when a jury acquits a defendant despite evidence because they either believe the law is immoral or wrongfully applied. But since the late 1800s, many judges took it out of their jury instructions.
And it's not illegal to fully inform jurors. It's just that judges don't do it anymore. And to me, I just feel like the justice system would be much better off, and we the people would be much better off if jurors were fully informed. again.
Another bizarre piece. Last Tuesday, while passing out the flyers, Keith says the magistrate, then a deputy, came out 3 times, saying he was not being detained, but that the judge wanted to talk with him. When he says the deputy threatened to have city police arrest him, that's when Keith went inside the courthouse.
She wasn't being rough, but she was kind of corralling me, and she was touching my jacket. And so I asked her again, I said, "Am I being detained?" She goes, "No, you're not being detained." Judge Jaklovic came out of his chambers. He looked at me. He looked down the hall, didn't know who he was looking at. And then he looked back towards me and the deputy, and he said, "Arrest him for jury tampering."
Keith refused to take a plea deal and is pushing to have his charges dropped.
I truly believe in my heart of hearts I didn't do anything wrong. I didn't break the law. So they need to drop all of the charges against me.
That's why there has to be pushback. And judges and prosecutors and people need to know you cannot squelch people's free speech rights like this and get away with it.
So there's a man thrown in jail for handing out a piece of paper with some information on it. And the information was just historical fact. There was no hate speech in this. He wasn't inciting anybody to commit a crime. It's just a flagrant abuse of First Amendment privileges and freedom of speech. So why do people in power have such a resistance against this man sharing this historical data? Exactly the same that I'm about to share with you right here in this video. Maybe someone will come and throw me in jail for making this video. I don't know. But people do not like you knowing about this. So to understand that question, we have to go back in time a little bit and follow this journey through. So 1215, the Magna Carta is signed. This is the Charter of Great Liberties. And it was citizens rose up and said, "Hey, King, you've got way too much power. You've been abusing your power. We need to set down a charter and limit your powers." The king acquiesces and signs the Magna Carta. Now, some of the powers in this, one of the doctrines that wanted to be created in this document was the separation of powers. Prior to this, the king made the laws. He held a court, but he hired the judges, and the judges basically gave the verdicts that he wanted, or he would have a problem with the judges, and the judges would be in trouble, fired at best, killed probably most likely. And the Magna Carta said, no, this can't be the case. We have to have a separation of powers. King, you can create the laws, but a person can only be deprived of property or their liberty, i.e. thrown in jail, if they are sentenced so by a jury of their peers. So the king agrees, but trial by jury doesn't exactly look like trial by jury today. What happens over the next 450 years, and there's multiple different, it evolves over this time, but there's lots of different things, but basically throughout this time, the night before a trial, the police drove around on their horse-drawn little carriage, and they kidnap citizens, throw them in there, and they kidnap 12 citizens, and the jury members spend the night in jail the night before the trial, and they're wheeled out into the courtroom on the day of the trial. Now, their job is to give the verdict that the judge instructs them to give. Failure to do so means that they can be punished. So it was not uncommon where jury members were deprived of their property when they actually finished the court case and went back home. Sometimes their houses were burned down. Sometimes their estates had been confiscated. And jury members could be punished if they did not give the verdict that the judges, who were the employee of the king, gave them instructions to do. So for 450 years, this hoax is what trial by jury is like. Until one day in 1670, William Penn and William Meade are arrested in London, England, and their crime is for gathering on a street corner and preaching Quakerism. Now, at the time, the Church of England was the only religion allowed by the king. You could not have any other religion. So they were effectively arrested for having a different religion from the king and gathering in a public space and speaking about it. This William Penn, by the way, was 25 years old at the time, and later in his life he would move to America, and eventually Pennsylvania would be named after him. He was one of the founders of Pennsylvania. So the trial begins, and a man named Bushel is named jury foreman. Now the trial is complete, and a foreman Bushel comes in and he says he finds the men guilty of speaking. Now, speaking is not a crime, so they failed to find him guilty of the charges that were brought upon him. And this is basically a slap in the face to the court. This is an instruction to let the men go. And the judges are absolutely livid. So what the judge does is he demands that the jury members spend an extra night in jail and they can come back tomorrow with their proper verdict. Further, he adds that the men shall be deprived of meat, drink, fire, and tobacco, and a chamber pot. Now, picture this. The 12 jury members are condemned to jail for the night. Now, picture a 1670s jail. It's just a stone room. There's no beds, there's no mattresses, there's nothing comfortable at all. And all 12 jury members are stuck in this room. They're deprived of a chamber pot, all food and drink. So these men sleep on the floor in each other's excrement and urine. They reek. They stink. They haven't had any food for a day. They haven't had any water for a day. They're cold. They were deprived of fire in London, right? It's a cold place, in case you didn't know. The following day, they come back into the courtroom. Once again, now, originally, by the way, there was only 4 dissenting votes. 4 jury members said that Penn was not guilty of the other crimes. Now, the whole jury members have been talking all night. They're angry at the judge. All 12 of them come back and give the same plea, right? He's only guilty of speaking, which is not a crime. The judge, absolutely livid, sends them back to jail for another night. They've spent 2 nights now. They come back to trial the 3rd day. Again, they're just covered and reeking in each other's excrement. It's horrific. They slept, if at all, on a stone floor in a prison. Deprived of sleep, deprived of heat, deprived of food. And these 12 men came back and all of them said, not guilty, which is the end of the court case. Now they're not just being cheeky and saying, I find him guilty of speaking. They're now officially saying not guilty. And the judge is absolutely enraged. He sentences all 12 jury members to 2 years in prison and fines them an average of 2 years' income. And all 12 jury members go off to prison. And after another little incident is taken care of, William Penn and William Meade are set free. Can you imagine the courage of conviction of these jury members? 12 of them choose to go to jail rather than let this injustice take place. Now, 3 months later, after spending 3 months in the Old Bailey in London, England in 1670, the 12 jury members get through the process of their writ of habeas corpus. They appeal the decision, and the appealing judge utters the immortal words, "The jury must be independently and indisputably responsible for its verdict, free from any threats from the court." And the 12 jury members are set free. And right there in that court case, established is the principle of religious freedoms, and most importantly, jury nullification. Now, specifically, what jury nullification means is the jury is free to find the defendants not guilty, even though the law was lawfully made through all of the procedures, whether it be by King or Congress or Parliament or anything else, and even though the evidence is there to prove that the men did the crime, the jury can still find the men not guilty because it's a bad law. Now, this common law held through all the way through into the United States and all over the Western world, and often in our history, jury nullification has become an important part of eradicating bad laws. In fact, most historians agree that the reason prohibition was eventually repealed, remember, prohibition was the banning of alcohol consumption and alcohol transport in the 1920s, the reason that law was repealed was because of jury nullification. They couldn't get any convictions. No one was willing to prosecute people on the basis of the fact that they had an alcoholic drink. Sadly today, in many courts throughout the United States, judges will lie, affirmatively lie to jury members about what their rights are, but even what their obligation is. Judges will inform juries that they are not allowed to question the law and that they must vote. If the evidence is there that they committed the crime, then they must find them guilty. And this is simply not the case. It's not the way it was intended. And it's not the way it was intended by the Constitution, right? Further, if a defense attorney even begins down the path of mentioning jury nullification or even comes close to informing the jury of their rights, the defense attorney can be held in contempt and can even be disbarred. There is this massive organization, new rules set in place to deprive the jury members of knowledge of their rights and obligations as jury members to judge the law in addition to judging the facts. And this is the data that was on this pamphlet that this gentleman was handing out near a courtroom. The result of this is that we have now regressed 450 years to where, with an uninformed jury, the only means of appeal, the only way laws can be questioned is if you go to the Supreme Court. And of course, the Supreme Court is a panel of judges that were put there in place by the president, which is the new king. It has eliminated that separation of powers. And if you're frustrated at some of the ridiculous decisions coming out of the Supreme Court, things like Obamacare is constitutionally appropriate, things like taxation is constitutionally appropriate, things like basically just changing the meaning of all of the words to make them contemporary and basically completely undermining the Constitution, that is all because this concept of jury nullification has been forgotten by society. We've just forgotten about it. And it's so critical and important to our liberties that, like I said at the beginning of this video, this should be something taught in high school at least, but I would argue middle school as well. But it's so much worse than that. And a little personal story here. My very first date with Mrs. Contrarian Dude about 7 or 8 years ago, on our first date, I happened to bring up jury nullification. Now, the reason I did that was she graduated in the top 3 of her law class, all right? And she had never, ever heard of this story. She just didn't hear about it. Even at law school, they will not teach you about jury nullification. So this is an unbelievably important concept. As Thomas Jefferson said, it is the best mechanism yet devised for the defense of liberties. And if you can please share this video, get it out. And particularly among people, like among these causes, like I mentioned, the legalizing marijuana cause, just informing jury members of their rights, encouraging them to get non-guilty pleas for these bullshit crimes, I'm going to say. This is the path of least resistance. Petitioning governments is just a waste of time. You've got a huge prison industrial complex that pays huge amounts of money. In California, I believe the lobby of prison guards, etc., and that union is the biggest union, biggest lobby group in the whole state of California. And so you've got this huge amounts of money flowing in, lobbying / bribing politicians to keeping marijuana illegal so they can fill the jails and make profits for people. And informing people, trying to go through politicians is just dumb. It's the slow way, begging your masters to change the rules. It's nonsense. The path of least resistance is to educate jury members and get them to find people who are not guilty of criminal acts not guilty. Doesn't matter what the law says, juries need to understand their rights and find people not guilty. And the reason I brought up this story is because my wife brought up a very important counter-argument which I want to address on our first date. She said, hang on a minute, this sounds terrible. Like, what about, this, you're in the deep south and there's some racist guy on the jury and some guy has been accused and did the crime of a white guy murdering a black guy. And what if, the jury members find him not guilty, or there's this one dissenting vote because he's a racist scumbag? This just undermines law. And perhaps even a more relevant one today is you have, the polls came out the other day, it's like 25% of people who are part of the Islam faith believe that people should be judged by Sharia law and not by the law of the land. And so what that means is you had someone on the jury who believes in Sharia law, then they can just go ahead and find not guilties or guilties and undermine the whole legal process. So this is a very valid argument, and I can totally see how those kinds of things can indeed happen. So one of the defense mechanisms that the whole jury selection process called voir dire, and forgive my pronunciation of that, I think it's a French term, if not Latin, but what this is the process of jury selection. And there's different rules in different states and different countries, and so I'll just give you a general idea of what that is. In order to choose the 12 jury members, they might bring out a panel of, say, 60 potential jury members. So that means to get from, let's say 62 for easy numbers, there are 62 potential jury members, and they've got to whittle that down to just 12. That means 50 people have to be struck and are not allowed to go to the jury. So the way that works is that the defense gets 25 strikes and the prosecution gets 25 strikes. And this is just usually how it works, right? Like I said, it's different in everywhere. But if you get to interview the jury members, you get to ask them questions, you get to find out what they believe in, and during this time, the jury members are obligated and under oath to tell the truth. So both the prosecution and defense get to dismiss 25 from what would be called, the extremists on this particular topic or issue, and you're left with, hopefully, the median, or the average of society, right? So the jury members are supposed to be a representative of the middle America in terms of their philosophy on this particular issue, whatever that court case is. Now remember what democracy is. If you take the fantasy of what democracy is and forget all the corruption and all the obvious things that go on wrong with democracy, you're left with the fantasy of democracy, which is people get to vote, and if 51% of people agree with a law, then their representative makes that law, and that becomes the law of the land. So if the majority of the people, like 51% of a population, are either racist or believe in Sharia law or any other example like this, then those things will be law. So the law can be racist as well. So through this process of voir dire and jury selection, where you select the middle representation of society, you neither gain nor lose any protections, because if society is corrupted and racist, then the laws will be corrupted and racist. If society believes in Sharia law, then the jury will believe in Sharia law. So you neither gain nor lose any protections with regard to the virtue of society with this process. But what you do get is a huge protection against government tyranny, and I would argue no cost at all. So guys, I really hope you enjoy this video, and I really hope you appreciate the sacrifice that 12 men 450 years ago made when they agreed to go to jail for 2 years to protect the liberties of just 2 men and preserve the right of jury nullification. I think it's an epic tale. It should be a Hollywood blockbuster, but the same people who own and control the government are the same people who own and control Hollywood, so I don't think we're going to hold out for that movie anytime soon. But I hope you share this video. I hope you like it. I hope you comment below. It's a fascinating story, and I'd love to get it out there as much as possible. We've got some great videos coming up, so please subscribe, and I'll see you soon. Take care.